Welcome everyone to the Guam Congress building. So the Committee on Health, Tourism, Historic Preservation, Land and Justice is now called to order. This is an informational hearing. The date is Thursday, September 19, 2019 at 2 p.m. I'd like to recognize the presence of the speaker, Tina Munoz Barnes. Available, but I've also, the Guam Bar Association, I think, is also available generally for legal interpretations, different, if they want a different, interpretation of any of the things that either of you have said. I'm sure that my colleagues are able to obtain those resources as well. But I would welcome anyone who's listening who also wants to submit testimony to please do so, particular to these legal questions that we've been asking. So I want to thank you, and I'm going to open it up for other members who would like to testify. Thank you. All right, so we have signed up, and there's several members who signed up that they are here, but to present oral testimony, I have David Lubofsky and Annalyn Lagribas. If you could please come up to the table if you want to present testimony. And that's all I have right now. So if there's anyone else who's interested, please sign up, and otherwise we will proceed. Mr. Lubofsky, whenever you're ready, please. You may press that the button on the microphone. They can make sure it's set. Okay, thank you. Just to let you know, I've given copies of your testimony also to my colleagues.
Okay. Thank you, Senators, for allowing me to come here and provide some information. I'm sorry, I have a little bit of a cold. My name is David Lubofsky. I'm the father of Asher Dean Lubofsky, who at age 5 passed away at the Guam Memorial Hospital on October 31st, 2018, almost 1 year ago. Let me first start off by saying, I don't want to be here. This is the last place on the planet that I want to be at, trust me. As what brought me here is the worst nightmare that a parent can face. The death of a child, as you can imagine, is an unrelenting, non-stop, painful nightmare. To make it even more painful, and the reason that we are all here is about how children and family members die due to medical negligence or malpractice needlessly, and those negligent doctors who then walk away with no accountability. Not even a record of what they did. There's no record of it. Which doctor did what? When Asher entered the Guam Seventh-day Adventist clinic on October 29th for his annual wellness examination, while also sick with symptoms, and he saw Shishin Miyagi, or when he ended up at the Guam Memorial Hospital the next day, I had no idea that my son was dying. I had no idea that he would die. And at that point, I clearly had never heard of the Malpractice Arbitration Act. I will not get into my anger over how Asher was treated or mistreated. You can read all that online. It's clearly stated everywhere. This meeting is about what happened to Asher and many other children and people on Guam after their death, injury, etc., due to negligent medical care. This meeting is about the Discriminatory Medical Malpractice Mandatory Arbitration Act that lets doctors walk away with no accountability after our children or family members are injured or killed by their blatant malpractice negligence. This meeting is about real people. It's about our kids. It's about the death of Asher. It's about the death of baby Faith. It's about the death of Zachary Joaquin. It's about the death of Aiden. It's about the death of Charlie. And the list goes on and on. All related to malpractice due to negligence and what I like to call is a legal cover-up with the Arbitration Act. Then the doctors who treated or mistreated these kids go on and treat your kids as if nothing happened. The very next day, they're back treating other kids. You don't know about the doctor's histories. You don't know what happened. With arbitration, they could kill many kids and no one would ever know. Is there even records of these incidents? With Asher's death, when it became time to hold Shishin Miyagi, Ethan Snyder's Seventh-day Adventist clinic and Guam Memorial Hospital responsible, we, like many others in Guam, ran into the Arbitration Act. We heard, if you could find a lawyer, we heard, oh, I'm sorry, if you want to hold these people accountable in the death of your son, you first have to enter arbitration and pay the huge expenses of it. I'm not sure the information we just received, that you just received, but in my case, we're talking $30,000 to $60,000. We hear this over and over. The parents here and other people hear the same thing all the time. That's why there's no record of this. That's why these doctors keep on continuing to do what they do. Can these doctors kill us, is my question. Kill our kids, then walk away with no accountability, as few of us can afford the process. The killers of our family are protected by a legislative-supported law, the Arbitration Act. How many families have buried loved ones due to negligence and were told the same thing? Sorry, nothing can be done. There is no accountability for doctors on Guam. The act makes it so people of average or low income cannot afford to seek justice. The act prevents due process or going to court unless you go through the expensive, drawn-out arbitration process. It discriminates against all of us, especially the poor. When I walked into the second nightmare with the Arbitration Act, it angered me much, and it still angers me much, as Guam doctors are a protected class, an elitist group that looks down at the rest of us, which is evident in how many of them conduct themselves and how we are treated by the Arbitration Act, and how they have discriminated against us, especially the poor in Guam. This does not necessarily apply to all doctors. It's not a generic statement, but it does, in my opinion, the Arbitration Act has created apathy, which has become part of the physician culture on Guam. This has been going on for 30 years. The Guam doctors know there's no accountability to the poor or any of us, as we can never afford the arbitration process. Does this play into how doctors treat us on a daily basis? Here's an example of something I just ran into this week. I had a parent this week, I'm not sure why they contacted me, but I had a parent this week message me over and over and finally call me, how they cannot even get a referral for off-island for a very sick 6-month-old baby that has seizures continually, as the doctor seems to be full of excuses for the mother why he cannot do it. The mother is on public assistance. The doctor told her, go see someone else, even though the child has been hospitalized with the same doctor at GMH multiple times, and she was at GMH requesting referral during the last hospitalization with her 6-month-old baby. Is he waiting for the baby to die? The parent is frantic. The doctor is different. My opinion, that is what lack of accountability does. Makes doctors apathetic. And they ignore the plight of our kids. This is what happened to Asher. No doctors saw him for the last 12 hours of his life. They left him in his room without checking on him until he died. And then they all ran in and said, oh, our condolences. This is apathy, and it's breeded by this Arbitration Act. It becomes part of the doctor's culture. Oh, I need to take a rest or whatever. You have a dying child and no doctors come into the room? The lack of accountability should anger everyone. Name any other profession on Guam that has no accountability as afforded to doctors due to the Arbitration Act. The difference is that our kids are dying. The law discriminates against the poor, and that was my biggest issue initially when I went into the Arbitration Act. But as time passed, and after talking to many parents, looking at my own experience and other people in Guam, it's evident beyond the discrimination due to the cost of arbitration, the law creates apathy among doctors, as I already referred to. A better name for this act would have been the Apathy Act. People who are not accountable for their actions and are protected, no matter what they do wrong, become apathetic. We as parents will never allow our kids to not be accountable, and we want our children to be responsible for their actions. But the people who take care of our kids medically, we do not hold them to the same basic standards of accountability that we hold our kids to. It doesn't make sense to me. Something's wrong with that. And actually, I went back and I looking back when the Arbitration Act was enacted, and I looked at the supporting testimony. And the most important supporting testimony that stands out was by James Gillen, who at the time was the administrator of the Guam Memorial Health Plan. In my opinion, he lays out the true intent of the Arbitration Act. He said at that time, prior to this current act being passed into law, that doctors were practicing defensive medicine because they were worried about being sued for malpractice. Doctors were practicing defensive medicine. Defensive medicine means that they were doing everything that they could for their patients, lab tests, diagnostics. Defensive medicine means being responsible doctors. Even though there were few of any malpractice cases at that time, 30 years ago, when Gillian gave his testimony, he was making the point that the doctors do too many lab tests because they feared being sued for malpractice. In my opinion, he was saying they were being too accountable as they worried about malpractice or being sued, and that this apathy arbitration law would alleviate that so they did not have to worry about being sued and could do less diagnostics with our kids. Let me translate this how I see this. Jim Gillian was saying that when doctors practice defensive medicine and do every test because they were worried it's going to do less tests, he was saying the law would make it so the doctors do not have to practice defensive medicine. They do not have to be accountable. Insurance companies would save money. Doctors would have lower or no malpractice insurance. And the stage was set for apathetical medical care on Guam under arbitration. It's hard for me to fathom the rationale of pretty much telling doctors through this law that they do not have to practice defensive medicine, which protected us up to that time. How many have died over the years as this apathetic medical care, a product of arbitration protection, became part of Guam's physician culture? Baby Faith, who passed at the Guam Regional Medical Center, never got simple lab tests, as that doctor seemed not to care and was not practicing defensive medicine. Asher Dean, Asher went into the SDA clinic with symptoms. He was dying at the time, we didn't know it. But they never did a simple CBC test, or even the wellness exam that we were there for and we paid for. They gave him about 15 minutes the doctor gave him about 15 minutes of his time. If they had done those things, the CBC test, a simple CBC, and it was reported that he had symptoms, maybe that would have saved his life. And this is a message for Jim Gillian. You did save money on these two dead kids, and how many others? How many other people have died in the same situation? You got your Arbitration Act passed, your insurance company saves money, and we're the ones who have dead children and dead family members. I would venture to say hundreds over the years. I would venture to guess that the Arbitration Act has dumbed down medical care in Guam so much that no matter how much money that you spend of our taxes on Guam Memorial Hospital will not fix the problems. Short of making doctors accountable, bring back defensive medical care. I think it's important to note currently, that the Arbitration Act is in court and is being questioned whether it's inorganic or constitutional. There is a current law, a case and being considered. The law in the past, as previously written, as you heard, was deemed to be unconstitutional. But according to a Guam Post story, Attorney Pipes implied that this current law that we are discussing today is also not constitutional. In any case, it deprives us of the right of due process to bring those who kill or injure our family members to court. Also, an interesting law which is being discussed in the House in Washington, it's called the Forced Arbitration and Justice Repeal Act, H.R. 1423, or the FAIR Act. This federal law looks like it's going to pass. And it will ban all forced arbitration and contracts, including health care. I would expect also legislatively enacted forced arbitration, like our Mandatory Arbitration Act, would be questioned if the law in D.C. is ever passed. Again, it's H.R. 1423. The acronym is the FAIR Act. The reason for this federal law is clear. People were getting their rights violated, were robbed of due process, and sold inferior goods and services, including health care issues, and had to deal with apathy and had no rights when these contracts were in place and enforced. The FAIR law has implications for Guam and should be the writing on the wall, if for no other reason that the arbitration law needs to be repealed. Okay, let's just step back for a moment, and I'm taking more than the amount of time that I was told that I have, and I apologize for that. Who protects us as citizens on Guam from medical negligence or malpractice? Who protects us? With the Arbitration Act, what options exist for the average person with a valid complaint against a doctor? What do we do? Where do we go? Every system of medical care should have a check and balance system with protections for the citizens. What protections do we currently have on Guam? What recourse do we have? Let me briefly outline two possibilities. When we have a problem with a medical person, we have the Guam Board of Health Examiners, and we have the Guam Board of Medical Examiners. We can file complaints with them, but this has been proven to be useless. The Guam Board of Medical Examiners gives off-island doctors licenses to practice on Guam to those applicants who only meet minimal qualifications. And to make matters worse, they have licensed doctors who have malpractice histories. They bring these new doctors here, put us at risk, while offering these doctors low malpractice insurance due to the Arbitration Act, which protects them from lawsuits. Some of these doctors may not be able to work anywhere else. But the board, led by Dr. Nathaniel Berg, does not seem to be worried about that. Then when we complain about a doctor or the death of a child, this board that has major conflicts of interest, including financial, will investigate and make decisions, not mitigating their own serious conflicts of interest, not interviewing the complaining parties, as in our case, the parents of a dead child, then release the results of their so-called investigation to the media before even telling the family what happened. As Attorney Thompson said, most doctors don't want to rule against their colleagues. And that's the problem that we went to the Guam Board. In my opinion, there should be an oversight hearing of the Medical Examiners Board and the law that created it. They were recently described as corrupt on a local news media. How many doctors in Guam have a history or claims against them malpractice, and they were then licensed by our board and brought here and put us at risk? How many doctors are already on Guam that have been investigated or there's been complaints against them for malpractice? Ask the board. It should be public record, but it's not. A doctor can kill our kids and go on to the next child in the next room, and this board does not have a public record, which is our right. Again, I'm saying that board needs an oversight hearing. Next, we have the Guam Board of Health Examiners. It's another place that takes complaints against physician assistants, as we filed, but they do not take complaints seriously and do not do what they are mandated to do. A dead 5-year-old child, Allied Board gets a complaint regarding a physician assistant who denied my son to see a doctor 20 hours before he died, among other things. 9 months later, the Allied Board has not done anything with the complaint. Nothing. It just sits there. They never even communicated with the family. When they are faced with complaints, they do not care, obviously, by their actions. Are they waiting for another child to die before they act on the complaint? Again, total apathy by this board. Still boggles my mind how they can see themselves as professionals who have the community's best interests in mind. It's clear. I'm sorry, I'm yelling into the mic. It's clear. We as consumers of health care, families, parents, etc., have no protection on Guam. We have none. Not from the politically appointed governing boards who are apparently self-serving, not from the courts through the Arbitration Act, and up to now, not from our elected leaders who have allowed us to suffer and die due to these problems with boards and arbitration. It's too late for my son, Asher. Nothing you can do will benefit him, won't benefit us, won't benefit me, won't help us in any case that we have. Our suffering will not be alleviated by the repeal of this apathetic Arbitration Act. I can walk out this door and it won't change anything for us. We don't have our son. But I'll tell you, it will give us solace to know that other families on Guam will not suffer as we and others have by making doctors responsible for destroying lives. You know what? Asher was taught the difference between right and wrong. And I always held him responsible when he made a mistake. Sadly, and obviously, his doctors and others were not afforded that same lesson in life. And the Arbitration Act allows them to continue on killing us. You want to improve medical care on Guam, save lives, repeal the medical arbitration law. Thank you.
Thank you very much, Mr. Lubofsky. I appreciate your testimony and the difficulty of your circumstances to come here to present that. I ask if any of my colleagues have any questions of Mr. Lubofsky or comment. All right. Thank you again.
Thank you.
And are you Annalyn Lagrimas?
Yes.
All right. Okay. If you can press that button on your microphone, you may proceed. Thank you.
So I didn't come here prepared. I came here straight from the hospital because that's where my dad's at for the past two and a half months at GRMC. I just wanted to get a story out there so that no one has to go through this ever. On July 1st, my dad was admitted in GRMC ER, conscious and complaining of a headache. The week prior, he was working in construction at the new Subaki Tower. While in the ER, he went into septic shock. A couple days later, he recovered and was conscious again, with suspected multiple organ failure. His kidneys shut down, so he would now be on dialysis. His liver, although in bad condition, was improving, as the doctors have said. He was expected to be discharged, as I was contacted by an outpatient dialysis clinic referred by the hospital in mid-July. However, mishap happened after multiple concerns brought forward about his fear of hospitals and not wanting to be here and actively trying to climb out the bed rails. He had pulled out his dialysis portal and bled out till he was barely conscious and was transferred to the ICU. Before then, he was on restraints, but that day it wasn't ordered for him, leading to the unfortunate event. The ICU doctor at the time, Dr. Augustin, said it's likely he would not make it, and specifically said that he is currently like a car that is not working, being moved by a tow truck, as he compared it to the life support that was keeping him alive. 2 weeks later, and off of life support, he made it. He had fought to stay alive. However, due to negligence during his stay, he had developed a bed sore that they had allowed to progress into a stage 4. And a critical state where the bed sore was now a giant crater-like wound that had reached the bone and is now the cause of his new infection that would most likely lead him back into septic shock, where he most likely would not survive the second time around. Had I not done the research myself and filed a formal complaint, they would not have attended to it, nor make me aware of his hospital-acquired stage 4 bed sore.
Sorry, Mr. Lagomez, can you repeat that last sentence, the last part?
Had I not done the research myself and filed a formal complaint, they would not have attended to it or make me aware of his hospital-acquired stage 4 bed sore. Because of my dad's critical state, I took it upon myself to research how my dad got a crater-like wound on his butt where he had never had one before. I learned that a bed sore doesn't progress into stage 4 overnight. It goes through stages 1, 2, and 3, and that with national standards are preventable at the early stages of 1 and 2, which I later found out occurred early in July 9, yet nothing was being done to treat it at the most basic level of care. He wasn't being turned every 2 hours or cleaned dry. Neither did the doctor nor nurses inform us nor address it. I had to look through his medical records just to find that out on July 9. As I have seen it visiting my dad every day for the past 2 months and a half, especially during the first couple weeks, doctors and nurses had rarely came to check on him or clean him, leaving him to lay down soaked in his feces for long periods of time unturned for at the most 12 to 8 hours, while other times it would be 4 to 6 hours. How would I know, you ask? Of course, because I was there. I was there to witness it every single day when my work schedule permitted. And had I known that was happening at the time, had I been informed in the beginning stages, I would have pushed for everything to be done to prevent it, which means getting something as simple as turning him every 2 hours to be done. Constantly ringing them to check on him, all the things that they are doing now after a complaint was made, and after I started to keep tabs on them, tracking them and putting in a time log. Everything that they have started to do now, which was technically their job, they should have done in the early stages to prevent it. Before skin breakdown. Complete skin and muscle breakdown should have been out of the question. Only now that a complaint was filed at the hospital that all the doctors started attending to him. I even had to personally request for the GRMC wound care doctor myself because they had not told me nor informed me that they had one. But now it was too late. The wound has reached the bone and it's infected. And they're doing the best they can, but that's the thing. They're telling me it's too late. GRMC boasts high-quality care and quotes patients as partners, charging $3,000 a day in telemetry and close to $5,000 a day in the ICU. Yet they couldn't give him the simplest care to prevent something ultimately preventable. The wound developed to such a stage due to negligence. At GRMC as a whole entity, a wound that massive doesn't develop from his kidney failure condition. It develops out of negligence, when the most basics of care was not provided to him on time and in a timely manner. And only now when it's too late, having let skin breakdown occur due to negligence, are they trying the best they can. And the most frustrating part is that they only did so because a complaint was brought forward. It makes me think, had I not said anything, would they have just left him there to rot unturned, leaving a bedbound person to lay hours there? My dad is suffering in pain and at risk of dying over something as small as a bed sore that they let progress for weeks. 4 weeks before even doing anything, letting it develop to a deadly stage 4 hospital-acquired bed sore wound with no viable options left on island to treat it. Attempts to contain it have been insufficient, and he is now in isolation. Surgery with a diverting colostomy is also not a viable option due to his health condition, making it very high risk of not making it past the operation. Also, the surgeon himself not only does not recommend it, but mentioned that there is no guarantee that even if he were to survive the operation, that the wound would be able to completely heal. So he just suggested that I spend as much time with him as possible. My dad's slowly dying from a hospital-acquired bed sore that was clearly preventable. The worst feeling is to feel helpless, knowing more could have been done to prevent my dad's suffering, who is currently defenseless at the complete mercy of GRMC, who has verbally acknowledged their mistake and is covering the cost of his prolonged hospital stay. But who's to say that because they are no longer profiting from my dad, that they can't just discharge him anytime as another form of malpractice? Having GRMC cover the cost of treatment to his wound makes him more vulnerable. The trust is no longer there. He's in the state of suffering because he was neglected. How can you let a stage 1 bed sore, treated with the most basic care of cleaning him and turn into a stage 4 crater-like wound deep to the bone in a matter of weeks? If you compare the difference to the standard of care they're giving him now, the surrounding areas are healing because they are turning him. Now they are attending to him every 2 hours prior to the past 4 weeks when they let the ulcer develop. When the right care now directly provides that it was preventable, Centers of Medicaid Services determines that way, thus making it a never event. So he has other bed sores that are healing, but then the one that they let develop into a stage 4 ulcer that should have had been addressed sooner is in serious critical state. So a hospital stage 4 bed sore is classified as a never event. Here in my poster board, I have it defined. Additionally, the financial burden to hospitals will also increase as the Center for Medicaid and Medicare Services, CMS, recently classified hospital-acquired stage 3 and 4 pressure ulcers as a never event, and that care for these ulcers will no longer be reimbursed. Appropriate cost-effective treatment modalities are therefore of the utmost importance. Emphasis must be placed on decreasing the incident to minimize morbidities and ensuing costs. According to the National Quality Forum, never events are errors in medical care that are clearly identifiable, preventable, and serious in their consequences for patients, and that indicate a real problem in the safety and credibility of a healthcare facility. Never events are defined as adverse events that are serious, largely preventable, and of concern to both the public and healthcare providers for the purpose of public accountability. They are defined as serious incidents that are wholly preventable because guidance or safety recommendations are available at a national level and should have been implemented by all healthcare providers. Each never event has the potential to cause serious patient harm or even death. The MMMA encourages the lowest quality of care because these hospital entities and health professionals are protected by this law. I want to make sure no one, no patient, no family member should ever go through the suffering my family is going through. Mandatory arbitration is not even an option. That is all. Thank you.
Ms. Lager, Ms. Sidusmasi, thank you for that. And I'm very sorry about what you're going through, you and your family, and your father especially. I appreciate what it has taken for you to come down here and testify while he's still there, and the research that you have done is just shocking, but I appreciate it all. Is there any member of the panel here who'd like to make a comment or a question? Senator Taitakui.
Thank you, Madam Chair, and I too want to thank you for coming down here, taking the time away from your father right now, and it's commendable what you've done on your research for him, and I'm so sorry that your family is going through this as well, and I'm hoping that I know you read your testimony, and it was hard saying it, so I really want to get the full grasp of your testimony, so if you could please provide us a copy of what you've written, I would really appreciate it. And again, Mr. Lubofsky, thank you so much for being here today and testifying. I know it's difficult for you as well. And your advocacy to, make people aware of what you went through as well. Thank you so much.
Mr. Lubofsky.
I just want to introduce Miss Monica. She has a picture of her son, and also Miss Faye. They were in the same situation with children passed away. Doctor said, sorry, have a nice day, as they walked out of the room. But they have pictures of their kids.
I appreciate that. Would you like to say the name of your son or your name? And I see his picture. That's your son?
Just hold it up.
Yeah.
This is Charlie.
This is my son, Charles Blas.
Charles Blas. My condolences.
My son's name is Zachary Joaquin Bagos. He was only 6.
My condolences. Zachary Joaquin. Thank you. Again, thank you all, and very sorry about the experiences that you have gone through. I'm sure there are many more in Guam who have similar situations. Hard for us to accept this testimony, but thank you. I'm sure it's more difficult for you to have to be here and to present it. Thank you. Thank you very much.
Thank you.
Again, so we have one more sign-in sheet. Dr. Nguyen?
Hi, good afternoon. Thank you, Senator, Chairman, Senator Talahi, Senator Taitakui, and Senator Marsh Saitono, and I'm really I'm sorry for the loss of your son and everyone in this room. I'm speaking as an acting president for Guam Medical Associations and Dr. Tom Shea's off island right now, but. As we go through this arbitration legislature hearing, we learn a lot from the two lawyers, Mr. Thompson and Mr. Bell, and also some concern on the arbitration law from the patient. There's a lot of misconception on what the arbitration law that we have in Guam and most of arbitration law that we have in the state. I think that for all of us, we will prepare as a group of physicians to represent the Guam medical community in the next hearing and the following hearing to kind of let everyone know what we have as of how we determine the standard of care in Guam versus the rest of the state. Just like Mr. Thompson said, it depends on location that you have. We have to practice, to the location. We can't expect to practice what we have in California or in Florida and Texas. It really depends on location. And the arbitration that we put in place and the legislature put in place is really, we just want to convey the message. It's not the protection of the physician, it's the protection of the quality of care that we have for the island or location where you are. You know, it's not for the physician, and this is something that I've been here since 1995. The quality of care in Guam improved a lot. We were very successfully, recruit a lot of physicians, a lot of specialty that is not here before. It's based on the arbitration law. Okay, so in the next two sessions, I say we will have testimony and probably PowerPoint just to kind of go over the arbitration as what we see, but it's a lot of misconception. So again, thank you for the opportunity for us to have this so everyone can be in the same table for us. Okay, and we have more information for you, and I have a lot of questions. You have a lot of questions, and I take those questions back, and we'll prepare our talk for you.
Thank you very much, Dr. Nguyen. Any questions? All right.
Thank you.
Thank you very much. I want to thank you all again for being here today. So this informational hearing will be continued on October 3rd at 5 p.m. We've invited again all the health professionals to submit testimony for that hearing, and a panel of to begin with the Guam Medical Association and the Guam Medical Society heads and any other medical professionals. We're also inviting any patients or other public to submit testimony at that time. There will be a third hearing on November 7, 2019 at 2 p.m. We're hoping to discuss options that are being concretely proposed at that time, if there are any, and some inviting anyone to submit those in advance. Again, these hearings are for informational purposes only, to allow senators to hear suggestions and make inquiry towards formulation of legislation. As of today, no bill's been introduced, so there will need to be another hearing if there is a bill introduced and for any particular change. The above described schedule is subject to change if a bill is introduced or if legislation session is scheduled during these times. So again, from the bottom of my heart, I want to thank all of you, and especially those who've suffered these losses with family members. We're very, very sorry, and my deepest condolences to you. But thank you very much for being here, for taking that really extraordinary effort to be here and to testify, and to remember your loved ones, and to make an impression on us senators as to what we should do as to policy. And I want to thank, of course, the medical professionals who are here for your interest in this. It affects all of you and our standard of care. And I think the bottom line for all of us is we all agree we want standard of care for Guam. And I know that's what you want. And so we're just going to do our best to try to ensure that there are many options. There's pros and cons on almost every one of them, on each one, as far as our research has shown. So, we just don't want to quickly move to one and suffer the cons of that one, as opposed to what we are suffering now. So we will be very deliberative in this process. So again, to my colleagues, thank you very much for your presence here, and thank you. Sizus Masi. You may submit testimonies to my office directly at the Ada Plaza Center, Suite 207, 173 Aspinall Avenue, Hagåtña, 96910, or to the mailroom of the Guam Legislature in this Guam Congress building, or through email at senatorterlahiguam@gmail.com. Again, this info hearing is recessed until October 3rd at 5 p.m. Sizus Masi.